I think we would all agree that you can't enforce a right that you don't have. Let me say that again. You can't enforce a right that you don't have. If somebody copied your brand tomorrow, your pricing model, your IP in general, could you stop them? And if the answer to that is probably, then you're already exposed. Because when your business is tiny, no one notices. But then you hit 3 million or 5 million or 10 million, and bigger players with deeper pockets and better lawyers start paying attention. And when they do, the fastest way to slow you down is poach your best people. Register your product names before you do, or maybe then hit you with a cease and desist letter before you've even filed your trademark. But if you move first, then you create what Ian Aldridge today, who is the person that I have interviewed, a lawyer, intellectual property expert, what he calls a shield and a sword. You don't just defend what's yours, you actually then own the right to enforce it.
And genuinely overall, I think small business owners and small businesses themselves, there's such a need for protection. When I was talking with a whole bunch of entrepreneurs and startups and small business owners, they were showing me what they were, getting in terms of legal documents and advice, and I was pretty shocked to see what they were getting, price they were paying for that advice. And being a litigator, I could drive buses through most of the stuff that I saw.
And he talks about how to identify and codify your IP before somebody else does. Why small businesses, including you, have probably got far more protectable value than you think in your business. And if you only had 60 minutes this week to start protecting that IP or even start understanding it, what you should actually focus on and spend that hour on.
Welcome to the ScaleHQ Podcast. I am Sean Steele, and I'm a growth mentor, digital nomad, a massive metalhead, and the founder of ScaleHQ. And you, more importantly, are a founder of a 7 or 8 figure services business who is finally ready to get serious about scaling up or securing a step back from your business or a life-changing exit in the next 3 to 5 years. And if that's you, then you are in the right place, because with over 100 million in revenue growth across my last 4 companies and many acquisitions under my belt, I have spent my whole career figuring out what makes businesses more valuable, scalable, and sellable. And I've learned a couple of things, and I'm thrilled to have an opportunity to share those with you today. So welcome to your fortnightly dose of practical strategy, founder success stories, and expert deep dives to help you finally get a return on all that sacrifice that you've made in your business. Welcome to the show. Let's dive right in.
G'day everybody, and welcome back to the ScaleHQ Podcast. I am so pleased to see your face again, Ian Aldridge from Progressive Legal. It's been a while, and it's lovely to be back reconnected, and today talking about intellectual property. Welcome to the ScaleHQ Podcast, mate.
Thanks so much, Sean. Really, happy to be here. Thanks for the invite.
It's an absolute pleasure. And maybe you could kick us off with a quick, who you are, what kind of problem you solve, like for who, like typical kind of clients, and how you do that just at a high level. So give a bit of context before we jump into this conversation.
Yeah. So I guess I'm now 20 years into practice as a lawyer. Formally, I did a few, maybe 5 years before that as a paralegal, going through uni, and so yeah, I've been in the law game for quite some time now. It's all been business related. I haven't done anything other than business, but the first 10 years of my practice, I was sort of pigeonholed into litigation and, disputes and dispute resolution. So disputes of all types of business, issues, finance, construction, etc. Dispute, and I started really general because I started out at a small firm, and so there was a wide variety of disputes that you'd get, in your early years of practice, because you just get thrown all the files and go off you go and let me know if there's a problem, but don't call me. But yeah, so for 10 years, I did that, worked my way up, the sort of ladder, so to speak, and small, medium, large, mega firms, and then a couple of years in the UK. But I found the bigger the building, the worse the job, and the worse the people. And then when I came back to Australia, I kind of missed that front end client interaction and giving you can actually you see the person you're giving the advice to, and it actually makes a difference. You see them implement it rather than working for a big corporate or big bank that you're a very small cog in a really big wheel on a matter that lasts 10, 20 years. I think most lawyers really start they want to practice law to help people. And I think, helping small business has been the most rewarding, personally, for me. Obviously you make way more money in finance and banking and all the rest, but I think helping people who are helping themselves and employing others. We are the engine room of the Australian economy, which certain political parties don't care about. But we really are the drivers, and we employ 60+% of the people. And genuinely overall, I think small business owners and small businesses themselves, there's such a need for protection for small business, because the smaller a baby cub is, the more protection it needs. Whereas big business get away with a lot because they can throw their muscle and weight and money around. But small businesses really need much more protection. And when I came back from overseas, I saw that when I was talking with a whole bunch of entrepreneurs and startups and small business owners. They were showing me what they were getting in terms of legal documents and advice, and I was pretty shocked to see what they were getting. And what price they were paying for that advice. And being a litigator, I could drive buses through most of the stuff that I saw. And so I was just like, oh wow, this, if this ever gets tested, this isn't going to protect you, which is what it's all about. I set up the firm 10 years ago now. We've just ticked over 10 years. We've helped 4,000 plus businesses that I can count. Awesome. Which is awesome. I'm really happy that we've been able to help so many people, and businesses, and see them grow. And as we're growing, our clients are growing as well too. It's wonderful. And they're doing all sorts of weird and wonderful things online, offline, with tech, without tech, and all sorts of really, really interesting stuff. And specifically now in the IP space, it's really interesting. So I've sort of built the firm over 10 years, designed it for what small business needs. So like they need structuring, they need IP, they need commercial documents, they need workplace, agreements, and privacy, like all that sort of, or anything commercial they need to get solidified and make sure that they're honky dory, and then disputes across those areas if there's something that does happen, and things do happen. You can't risky business. The business is called risky business because it's, they call it risky business. It's risky.
Yeah.
And you can only ameliorate, reduce as much as legally possible the legal risk in the business and other risks, also. And the rest is, you may not be able to predict or affect. So, but what I find small businesses that do that process and make sure that they try and reduce the level of legal risk, and sometimes that overlaps with tax risk as well too, from a structuring perspective. And just there's some really simple things that most Australian small business owners are not sort of doing, and I think that's partly because I think law's been done pretty poorly in the last couple of 100 years in Australia, and I think there needs to be a change. I think anecdotally, like 75% of Australian small businesses probably don't have a lawyer that understands their business, that can talk to them in plain English, like what we're doing now. There's no legal jargon, it's just straightforward, practical advice, no BS, and just honing in really carefully on like, what are let's go after the major risks, let's cover them off, and then let's work our way down. Really what we do is risk management. I'd say probably 75% of small businesses have an accountant, or someone to go for legal, for financial and tax advice, like at least 75%. But it's the opposite for lawyers. Like I think 75% don't have a lawyer that understands their business, that they can go to from time to time for any legal issues that come up, or scarily have never gotten legal advice.
No, I think it's, what I observe is that I think there's probably a lot of fear around pricing and who to work with, and there's such a broad spectrum. And what I liked about when we first met, one of the things that really attracted me to you and your business was the straight talking, was the Google reviews, which, by the way, Carl Schwantes, if he's listening, will be very excited about because not many people really nail their Google reviews, and you've got very healthy
Right.
Google reviews from your customers, which says to me that your positioning around kind of fair pricing and clear, like fixed pricing packages and all sorts of things, like really you have set your business up. So rather than saying, oh yeah, we help small businesses, actually your whole business is designed in such a way that it is designed for those kinds of customers, and everything from the pricing to the team to the processes seems to be doing the work. But one of the, I guess, you do a whole bunch of things from a legal perspective for small business owners. But what we wanted to dig into today was into intellectual property because
Yeah.
it's a bit of or not only is it a specialization in your business for founders that are scaling, ultimately, when they're kind of sub 10 million, they're still trying to build an asset. So they usually are pretty pro risk. Let's just keep going. Let's see if this thing works. And then they get to that stage, and usually it's like, the business is now working. It's a reasonable size. I've got a lot of responsibility. And now I start thinking about protection. Like, how do I now start to reduce risk? Because now kind of the risk profile of the business has changed. I don't want to screw it up because I don't want people to lose their jobs. I'm now protecting families. I'm got all these clients. I've got more responsibility. So my radar as a founder starts to change and think, oh, okay, well, maybe I should probably shore up that agreement. And I know I'm doing like a JV over here, but it's all handshake, and maybe we should actually have an agreement around that. And, we've been, our employment contracts, we've probably had them done, but maybe it's been done by like a HR admin sort of level person and not really had any kind of good updated IR expertise, etc. So I guess today what I wanted to do was to just kick off with imagine you've got a new COO that's just started in progressive legal, and you're explaining like in a really short way, like what is the deal with, what's the real issue here when it comes to IP law? Like, why is it a problem? What are founders missing? How should they think about it?
Yeah. I think I'll start with a quote by James Getty, who's the Getty Images guy. The Getty family. They're very they did that movie about when his son got abducted and he wouldn't pay the ransom. Anyway, loved money. Getty's quote was, intellectual property is the oil of the 21st century. And he said that quite a while ago. And you look at it now, what's happening, right? From a top down, bottom up approach from the market, the top 10 companies in the world now, they're pretty much, they're all tech. Apple, all tech, Facebook, Meta, Google, Amazon. Yeah, sure. They might have physical warehouses or physical, stores and all the rest, but really it's all ancillary to the real value of the business, which is all intellectual property. Nvidia is, sure, they make microchips, but it's the technology that they have. That's what's the most valuable. And so if you think about that, okay, the top companies now, we've gone from this, General Motors and big oil and gas and all the rest to now, tech. There's also this bottom up, real big push. Like there's, there are still businesses that are starting out with bricks and mortar, right? There's always going to be them, but most of the businesses that are starting out now, they're tech focused, they're online, they're running from laptops and they're building software, they're building apps, they're building technology, they're building some businesses that's heavily based on tech, or they're building AI solutions now, which is going to be the next very big phase. So really, whenever there's value in wherever the value sits in a business, that's where really the focus should go in terms of protection, because without it, then the business can be in a lot of strife. When intellectual property has always been this sort of nebulous concept, but if you do an audit of actually what the business owns, business owners are very surprised about how much IP there is in their business when they actually add stuff up. And so when businesses start, what you've got to realize is you've instantly got a business that's potentially valuable. You might have a brand name or tagline, logo, slapline, tagline, byline, whatever you want to call it. Yeah. There's the product that they're inventing that's valuable right from the start, regardless of whether you might know it or not. Websites, designs, domains, trademarks, the copyright, the idea, the know-how, research, etc. That's all actually, intellectual property. Copyright is, any literary works that you've produced. So
What about,
I,
Ian, can I just ask one quick question there about a process? Because, there's a lot of founders that are listening today who have services businesses. And one of the things that we end up in a lot of conversations around with service business owners is differentiation, because usually what they do is not very different to the person next door. Like if you're an accountant, well, you do the same things as the accountant next door, most likely. Even if you're providing, I don't know, offshoring, well, the
yeah,
offshoring companies, they're pretty much doing the same thing, but the differentiation is in the how. It's how you do that
yeah,
thing. And the customer
yeah,
is essentially willing to pay a price or perhaps a premium price for your proprietary process, like your method to achieving that thing. And a great example of this is a founder I know in Brisbane who I interviewed many years ago from ProTech. ProTech's like a very large labor hire workforce supply company. They're like 4,000, well, this was 3 years ago, it's probably got 8,000 by now, but 8,000 people. And the thing that was interesting is like, well, labor hire is just like anybody else's labor hire. But what they did was to engineer the process in which they assess candidates, test candidates, prepare candidates, get to make sure that they've got the highest chance possible of that
yeah,
person being A grade when they rock up on site. So his process was the thing that people would pay for. Ultimately, they're paying for that process being applied to produce a better outcome, and he can charge a premium.
yeah.
How can that process be trademarked? Is that kind of the core value that
So
can be protected in the service business?
yeah, so it's a really good question. It's an interesting one, and everyone's got their own sort of, and these are sort of trade secrets, effectively, right?
Okay.
Because they're, you might be able to, and there's certainly you could trademark the trademark that process, unless it's really novel and new and inventive and um, and and um, and involves something that's really, really unique and tech based. You might be able to apply for a patent for it.
Okay.
But the downside with a patent is you've got to disclose everything.
Right.
And that's why some trade secrets, like recipes and stuff like that, they're all trade secrets because they can't necessarily be protected because yeah, exactly. And it's that, and pricing structure and modeling and that sort of stuff that business owners invent for their particular business, or particular questionnaires, etc., that have a process to them. They're much better to be held in-house and under lock and key with really, really strict and robust confidentiality agreements, either NDAs with anyone they talk to about it, or within employment contracts or independent contract agreements, making sure that the IP provisions and the confidential information is really carefully defined, and make sure that if there's a breach, then there's real consequences for that breach. And depending on the value of that intellectual property, then you obviously go further and harder and deeper at that to make sure that, like no one knows, I think, they've got, the recipe for Coca-Cola is one of those famous ones that's, held on lock and key and in two different safes and all that sort of stuff, with only two keys.
Well, I imagine that, I was just thinking about like the perceived value of a trademark, because, if you're a customer, let's just say you're going to, I don't know, a recruitment business, let's just say they're executive recruiters, and you got like recruiter A that's just like, yeah, we go and we do search and we interview people and then we provide you the short list and then hand them on. And the next recruiter goes, we have a proprietary process called the Ian Aldridge method, and it's trademarked. And in reality, it's going to be small things. Like it might be a couple of actually interview questions that they use that they found really helpful, or a couple of ways of behavioral testing, or a psychographic, a psychometric tool they use, or a bunch of, and they probably don't own, like it might be somebody else's psychometric tool, but I'm thinking more like, the customer's perspective of value, that you've gone to the effort to trademark a process that and assuming that you actually get results, that you can prove delivers out of the ordinary results. That seems very worthwhile to me to be able to defend higher
Absolutely.
prices.
I mean, we've all watched the Shark Tanks and Dragons Dens and all the rest, right? When they see something new, a product, an invention, or a process, how the first question they ask is like, have you got a patent? Have you got, what's the intellectual? I mean, apart from tell us what your revenue is, and how long you've been doing it and who's in the business. But like then it's a case of like, okay, have you got a patent? And sometimes I'll say, do you have the patent with you? I'd like to see it. And so, and they'll actually, yeah, I've seen that actually happen. So, but I think when you look at it from and anyone that's going to be investing in a business, anyone that's going to, come on as a shareholder of a business, anyone worth their salt is going to want to conduct some form of audit, right? Due diligence before they hand over a fat check. And you know how we're always trying to build businesses that they're saleable, right?
Yes.
This is just part of that. This is one of their massive tick box items. And some of them won't even hand over checks unless you've got trademarks done for the business, because they know, because they've been through lengthy trademark disputes before. They're like, bye, come back when you got the trademark registered 8 months later. So unless you've kind of done all these things, what you want to be in a situation where when they come knocking, your structure is all right, all the intellectual property has been identified, if it's been created by a third party, it's been assigned and done properly by way of a deed of assignment. Our Copyright Act is really prescriptive on that front. The trademarks have all been registered, as much trademark protection as they possibly can have over all of the valuable bits in the business. All their derivative products, the branding, the name of the business, all the rest, basically so that, hey, there's less risk of someone coming along and saying, you're committing trademark infringement, you're passing off, we're suing in the federal court. So like and your structure is right. Your structure is set up for sale. There's nothing that needs to be done before we do that. All the employment contracts are in place. Are they all legally drafted? Like, oh, you've got a big deal with one supplier. Where's the contract for that? We want to see that, because that's a major lifeblood of the business. And if it's like, oh, it's just a handshake, they're like, well, come back to us once you've got that legal agreement done and secured. These are,
well, to riff on that for a minute, because obviously I've spent a lot of time with founders working on building their business for exit or building it for investment. Not that many are acquiring other businesses, but some of them will in time. But having sat on the investor side of the table on many deals, these are all things that are relevant. If you think about what is going on in a deal, whether I'm investing or whether I'm buying outright, three things are happening. One, I'm going to buy the business based on the future growth potential. So that's like the first tick. If I don't believe in the future growth potential of the business and the business's ability in terms of its sort of foundations to access it, then I'm not buying it all.
You don't need to go any further.
I have to choose a price that I'm willing to pay, and I'm going to assess the price I'm willing to pay generally on past financial performance and the sustainable level of profitability that I expect the business has, and that's going to be on the past as opposed to the future, usually, like current to past as opposed to sort of current to future. And then finally, if I can tick those two boxes and I go, okay, I want the business because I believe in the growth potential, I'm comfortable this is a price I can afford and I've got financing or whatever to pay for it, then the third question is, what are all the things that can go wrong in this business that will basically devalue the money I just put into it? And so that's the red tick list. That is, a group of analysts or, corporate finance guys with their, junior burgers going through absolutely everything, which indeed, yes, of course, we're going through all the financials and the tax and everything with a fine tooth and we're going through all the people. We're looking at the quality of the people and the culture and all the other stuff, but we're absolutely going through the stability of the contracts, the quality of the employment agreements, like how stable are things, how protected are we? And that would include trademarks. If they've got some proprietary process that is a major differentiator in the business, how much protection do we have around that, so that we can kind of defend and build a moat? It's part of your competitive moat is the things that you can protect, but also the thing, not protecting everything, but protecting the things that are different, because they're the things that are actually creating value, as you said. So I like the idea of thinking about intellectual property, the start of the discussion going, where's the part of my business that actually creates the most value? That's the place to start a discussion about the intellectual property opportunities as the business grows up.
it's like in your house when you're insuring it. Like, you can look at all the little tiny things, but like the painting on the wall might be $50,000.
Yeah.
Like, well, let's start with that. And start with your jewelry, start with the stuff that's worth a lot of money.
Yeah.
So, and I think because it's fairly new, right? I mean, all this intellectual property stuff is it's exploding, because and so everyone's knowledge about it is really playing catch up. Like, I mean, just generally, like, in the intellectual property space and IT and AI, like, man, there's so much stuff coming out very fast. It's very difficult to keep on top of it. Even if you enjoy it, even if you really are on the ball and tech savvy. I'm not the most like tech savvy person, but I'm really interested at what's happening and where, and getting on top of, where it's going. So like, we're just having to really like play catch up now and realize that, hey, this stuff is actually valuable. And if you protect stuff and you, and you solidify things and you're really like running a professional organization, if you do things professionally, then you'll look better from an acquisition point of view. It just so happens that it's better for business because you're reducing the risk. If someone comes along that's attracted to buying in or buying you out, it's way better than pulling yourself up by your bootstraps afterwards. By which time the check might have moved on, the checkbook might have moved on.
Yeah. One of the things I'm thinking about as a sort of underlying, like maybe an unseen benefit of trademarking, like let's say a process in a services business, for example, is it actually forces you through the process of thinking through what matters and kind of codifying the IP as you go, because I assume you can't really do a trademark unless that stuff is really clear. And what that does is essentially you are designing a system. Whilst you do so, that is a system designed to produce predictable results that create value. That is a massive business asset, because that's the thing that you need to be able to scale. If you think about what happens in a business when they're kind of growing up to 10 million, and it's a surprising number of found once businesses get past, like, there's obviously a lot of failures pre $1 million, but the success rate once they get past 1 million is actually quite high. And okay, they don't all get past, of course. I'd like to put it in context. There's 2 million businesses in Australia. There's about 200 and something thousand that are north of 10 mil. So about 10% of the market is north of 10 mil. So, but what happens is, is the scaling challenge is, how do I systemize my success? Basically, that is the scaling challenge. And that's people, that's process, that's technology, it's everything. And up to 10 million, you don't usually need to systemize it that much, because you're actually usually relying on the excellence of people. Like, I've recruited some good people, they're super loyal, they're hardworking, and we're just putting our best efforts in, and we're creating some awesome success. But then we get to 10 mil, and that is not going to continue to scale. Like, if that stuff doesn't become systemized, you cannot rely on the goodwill of people at 20 mil, at 30 mil, at 50 mil. It doesn't happen. It starts to fall apart. Everything's on the founder, still making all the decisions, blah, 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 all the usual kind of scaling stuff. But I like the idea of the fact that perhaps you think that, perhaps if you're listening, you're thinking, well, maybe my stuff's not that special, but wouldn't it be an amazing opportunity to actually work through the process that would force you to think about the stuff that is valuable and actually codify it and systemize it? So whether you actually trademarked it or not, you get the benefit of the codifying and systemizing something that creates value, but then the trademark on top of it actually gives you that extra bit of not only protection, but differentiation and potentially pricing leverage, because you have something that's different to the other competitors who might be doing similar things, because your how is different, but now demonstrably different, evidence-based being different. So it's trademarked.
Yeah, when you look under the hood of any business, and 2 businesses that can look identical next door to each other, what happens internally is very different, and the way they go about those things, even down to, like, so say for instance in our business, like we've just gone through what you were just saying about, we're systemizing everything, all of our, policies and procedures, manuals, how-tos, questionnaires, master precedents for this type of thing, that type of thing, this way, that way, to, mutual, etc. and you can imagine in business how many of those we have. But we've obviously amassed all this intellectual property over 10 years, and now we're like, you know what? If we don't, I know that if we don't get this stuff down in writing, then we're relying way too heavily, firstly on stuff that's within, minds of people or documents that have passed long ago. There's all this stuff we can capture, build all the master stuff, build all the, template emails and, advices. And if they're doing this, then you consider that, and all the combinations and permutations of different things that happen. And you'd be surprised when you start to go through that process, how much actual intellectual property you have. Like, just think about your inbox. Basically, anything that's come in or out of your Outlook is like, there's a lot of IP there, and AI will show us, fully what, the level of that IP that's there. But you'd be shocked. Like, how many emails do you get a day? I get 250 plus now, that are going in and out of the firm. And there's so much knowledge, there's so much stuff that needs to be captured, and then it's a dual purpose, right? It's great because you're going to save yourself that time when you have to do that thing again, and not rely on your memory from 6 months ago. And we've all got memories less than goldfish now.
There's also another, I'm realizing in what you're saying, there's also another kind of unseen benefit, which is, as your business grows up, usually you'll have a few people that have kind of been with you from the start. Usually they've been super loyal. They're generalists. Usually they're super loyal, passionate generalists. They love you as the founder. They're committed to the business, and they may not be the right person for the next stage, to be frank, because what got you to here may not be what needs to get you to there, and they might actually be now a wrong skill set for the next stage of the journey. However, we're usually scared of those people leaving. Why? Because we're like, they know so much about the business. They have so much knowledge about the business. But that is, case in point, how much stuff have you actually got systemized, codified, processized? Because that's one of the things that actually gives you, it like reduces that anxiety of this person could leave. It's like, well, somebody else equally awesome, but who's got the next skill set, who's been to the next stage, could come in now to that role, look at what we've got and now improve on it, as opposed to me being scared of somebody leaving because actually they know sort of almost too much. Like that's not a balanced power relationship.
And isn't that a risk for the business if they were to leave?
Definitely a risk. Yeah.
So like, I don't sugarcoat stuff. Like, we're really just in risk management. Like, that's all we are. We're just risk managers.
Sorry, and your mic, I'm just going to pause for a second. Your microphone just got a little bit further away from your mouth. It just went a bit quiet.
Yeah, no worries. How's that?
Yep, that should be fine. Still clear.
Yeah, so I don't sugarcoat what we do. It's really just risk management. And so making business owners aware of where the risks really are in their business, from a legal perspective. That's and then just doing what you can to protect it, or to get it down in writing so that it's there. It's perpetual then, so that then if some people do leave, they don't leave with everything in their head and then it's gone, and then you have to start again.
Can we jump into a bit of a how-to? I think we probably unfurled a lot of the benefits to kind of the why, like why does IP matter? What are some of the benefits and so on? But what about the how? Like, let's imagine I'm a founder. I've got $5 million in revenue. I've got a technology company, like I'm selling software as a service. Maybe it's like services plus software, something like that. And business is going well. I've got good early traction, and I'm now thinking about entering the US, the market that all Australian founders would love to crack at some point, if they've got something that's kind of scalable. But I haven't actually secured any trademarks. I haven't really got a kind of IP component to my strategy. I'm just thinking about sales, basically. Like, how do I get on the ground, get sales? Who do I engage? Typical mindset for us. And like, what would you do step by step to help that founder through that issue? How do they think about it? Like, take me through the process.
Yeah. So whenever someone's coming to me in that sort of situation, I always like to start with the product or the service itself. Who created it? was it done by a third party? And if it was done by a third party, let's make sure that the agreement that they've got hands, assigns all the intellectual property over, and just make sure that that's all tied up. If it was done by an employee, just to make doubly sure in their employment contracts that there's nothing that's out of their employment contract. So as in, the rule at law is that if you're an employee for a company, then the company owns whatever you create.
Yeah.
But if you're a director and you don't have an employment contract, I know it sounds bizarre, but you're better off and safer to make sure that intellectual property is assigned to the company, and obviously if a third party's been involved in any way, shape.
You might have had freelancers from Upwork or whatever, but participating in something like that.
Mate, absolutely. And of course, Fiverr, Upwork, and all the others, they all have different terms and conditions. So, and all the, and around the assignment of intellectual property, some of them just say, oh, it rests in the creator. The others say, oh, well, let's hand it over, upon monies being handed over, and the work and the money's coming back. Others say, up to you guys, like you guys sort it out. But prefer, like, almost, I'm going to say blanket. It's much better just to make sure you get an assignment, get that handed over, just to make sure that it was not only created by them, which there's been a lot of stuff that we've uncovered when we started to get graphic designers to sign off on a document that says that they've actually created it themselves. So, so amazing. Anyway,
who's created it to make sure you
ownership of the IP, and making sure that the company owns it first. Then, either at the same time, we start looking at, is there a way to protect that intellectual property, either by way of, could it be a patentable invention? There's lots of people with lots of opinions out there that, you can't patent a piece of software. It can be done. It's difficult, but it's not impossible. And it all depends on how it's designed and what it does. So just to at least explore that option to make sure that, if there is a potential to patent it, then go down that path, get that advice and the costs, and then make that decision once you've got, with that information. The name of the product is going to be definitely something that they have probably come up with. So we look at the trademarks, we look at the Australian registers, Australia, New Zealand, and go at the particular jurisdictions which they think are going to be the ones that they move to next. Usually a founder will say, oh yeah, the US is definitely what we want, or actually the UK is our first port of call because that's where this is going to be. That's where we've identified. Or
like a state by EU. Are you like registering it for states that you end up selling into, or a whole country?
So the US is US, Europe is Europe. Brexit obviously happened, so now UK is on its own, any other country, it's country by country.
Yeah.
So I would, then we do search of all those.
Trademark the name of the product. What's next from there?
So we look at domains, we look at who's out there, social media handles, general Google searches. Usually they will have done some of these searches already, but there's, sometimes there are trademarks, for instance, that sit on various registers that are not well known, or they're in the process of being developed. And there's sometimes big US firms that sit on the Australian register, because they're just about to develop something here, or they've been training, but it's not easy. It's not easy to find them by those general searches. So we're looking at, those names and taglines and logos, whatever they want to protect. And but we start with the name, because usually that's what's the most valuable in the business, the name of the product, for instance, and start to do some knockout searches, like clearance searches, and then look at the prospect of, sorry?
What's a clearance search?
Just as, you're basically looking at these registers and working out, one, is there anybody else that's sitting on the register that's that is likely to come up as an objection if you try and file a trademark over the particular goods and services for which you want to nominate. So we would have run out of names long ago if we hadn't had this, the classes of goods and services, so that, McDonald's and McDonald's accounting could coexist, or Dove soap and Dove chocolate, progressive insurance and progressive legal. There's, otherwise we just would have run out of names. So, and that's why it's good to come up with something really novel, unique and inventive like Google did, because the word didn't exist before they invented it, I don't think. And so that's why they were easily able to trademark it all the way around the world, because it's a made up word. But you try and file anything with Apple, doesn't matter what you're doing, you're going to get a letter from Baker and McKenzie. That's what it's like. And so there's lots of businesses that are on the registers that you may not realize that are actually out there that have a registered trademark.
Yeah.
So that then comes up as a red flag, like, okay, we need to have a look at this. Where are they? What are they doing? Are they over the overlapping services? And then and then look at were they operating before you, after you, etc.
Yeah.
There's a whole bunch. And in what jurisdiction? Sometimes there have been businesses that have, started off with a name in a particular jurisdiction, and then had to change it, but just in that particular jurisdiction. So yeah, when you talk about globally, then obviously there's a bigger search that needs to take place based on those jurisdictions. So then gather all that information, prospects of success, likelihood of any objections, and then obviously the costs in doing so, because obviously there's the costs in filing in overseas jurisdictions does start to really mount up the number of jurisdictions that you file in, because you're usually paying per class, per application. So the number of trademarks you want to get registered in, the number of countries over the number of classes, that starts to add up. And then, we make a practical decision, a timeline about what's done when, and just stepping through that process. Sometimes it's a case of, okay, if this is available, this is available, this. Okay, great. Go ahead, grab everything in one swift swoop. Or we file a Headstart application, and usually the international applications are based off the Australian mark. So we file a Headstart application, which is a really great process through IP Australia, where instead of 2 months that it normally takes for a trademark to get assessed, this speeds up that examination of the mark. Within 3 to 5 business days, you'll get a response back from IP Australia saying effectively what they would do in 2 months' time, but done faster for an extra, I think it's like extra $30 a class or $80 a class. Like it's a nothing, like a no-brainer to find out. Now it's a confidential process, so you don't, no one would be the wiser if you weren't to continue with the mark. It doesn't even go on the register. So basically, if you want to test the availability of it, you file a Headstart application, see what the results come back. If the results are all clear, bang, you pay the part two fee, and it goes onto the register, and you can grab everything else at the same time. Grab all the domains, the social media, the business names, company name. But yeah, we ordinarily do a really big sweep of this first, and go through and see what the availability is like. How is it used in the market? Is it a common usage term? There's a lot of people with business names or products ideas that are kind of does what it says on the tin. It's too descriptive, not distinguishing it enough from other goods and services. Not to say that you can't get that, you can't get that protection at some point, or some protection. We can usually get at least some protection over the words. Or combining the individual elements together. Sorry, Sean. Combining those individual elements together to be able to get some registered protection, but you whittle down the individual value or the individual elements when you combine them. But at least you get some protection, and some is better than none.
Yeah. I think one of the things,
sometimes businesses will even have trademarks put on the register, and they're, in a way they're kind of done in a protectionist way. Even though they're not able to get them on the register now, they'll file, and they'll keep filing again and again and again until they have enough evidence of use in the marketplace to justify and say to IP Australia, hey, now after 5 years of trading, 10 mil turnover, whatever it might be, or 3 mil plus turnover in 5 years, we've spent all this money on marketing activities, and because we're really well known in the space, do we get our trademark now? And the longer that goes on, the more marketing and all the rest, and depending on the strength of the objection, and then usually IP Australia will allow you to have that once you've made that investment, spent that time, and they'll just require a number of stuff to kind of show all that information. Apple's a really good example of that. They couldn't get the App Store through for 10 years. They spent a shared load of money until they got, because the strength was so big, like it was just such a big objection from IP Australia. It took them 10 years. This is the biggest company in the world. It took them 10 years, and they kept going and going and going every 18 months until they finally got it after 10 years. But they got it.
This is going to be a hard question because it obviously is a piece of string type question. But like, I think one of the things that scares founders about even starting the process, they have no idea how much this costs. So let's just say if they're an Australian business that has no intention of expanding overseas, like they just operate, I don't know, in Queensland or Brisbane or New South Wales or something like that, and they're thinking, I just do, like, I've got a painting business or I don't know, scaffolding or a recruitment business or an accounting firm or whatever. And I'm like, I don't think we're that special. Okay, but the business is becoming more material. I do want to make sure that I'm protected. There's more value now that I care about protecting the risk on. How should they think about like how much this, let's assume they're not going, there's nothing patentable. They don't have any kind of like super unique software. It's just a services business, but of course they have a brand name and they might have a tagline and they might have a sort of proprietary process. Like, how should they think about how much this costs?
I don't like to scaremonger. It's never been a comfortable way for me to market our goods and services, because I think generally business owners need to think about legal advice and legal protection like insurance. Like, you're mad if you don't have it, right? Or you're playing Russian roulette with the business if you don't have insurance. The right insurance is in place, right? And I think we kind of need to think about from some perspective, like, and I know it's hard because as founders, we're in the business all day, every day, and we're trying to think, about this and that and the next move and what's income producing and all the rest. But I do try and encourage business owners to think about, their accounting and legals. Just like, that's the stuff you don't take the risks on. You can take the risks on all the other sort of stuff. So, but protecting your business baby should be the number one priority. So how do you protect it, and how much are you prepared to invest in just protecting it so that somebody else doesn't come along and start to trade off all of your brand and your goodwill over, say you've got a 10-year-old, 20-year-old business. Like, isn't that worth more than a 1-year-old business? Like, then if you haven't done this stuff, like what's a couple of grand to get,
I think I guess this is the point, is there's no, so maybe you could help me by just giving me an example. It can be a hypothetical example. It doesn't have to be a real client, but it's like, if there was a client that, was a plumbing business, they had a bit of a method that they thought was different to everybody else's method for doing their plumbing that they teach their people. They've got a brand, they just operate on, I don't know, the Central Coast of New South Wales, but $10 million business. And so it's a decent business. They want to do some level of protection, but they're not going to enter a process where it could be $1 million or $5. Like, it's just too big a range. But like, if they want to trademark, for example, the process and the brand and the, I don't know, the domain or something, but, like, what would be a typical amount that they use? It like a $5,000 process, is it a $100,000 process, a $500,000 process? Like, can you give me some sense of?
Yeah, I mean, if they just wanted to trademark, trademarking the business name, like, $2,000 to get that from go to woe, like, tax deductible, expense. Like just a cost of doing business. It's not, doesn't all need to be paid up front. That's the other beauty. Plus, the issue really is if someone else comes along and starts to steal that intellectual property and starts to damage the brand, or taking clients, taking key members of staff, taking the process, replicating it, all that hard work, like
if they want to trademark the process and call it the Ian Aldridge way, how much is that? Like, what sort of range would they be talking about? Kind of adding that.
Oh, I mean, it's the same again, but I mean, I think it's the investment there would probably more go into making sure that that's probably more of a trade secret than something that I would necessarily trademark, because then you're sort of giving it to anyone that want to have a look at it. Normally you're using trademarks for badges of origin for your business, like your name, your logo, your tagline, your derivative products, anything that kind of distinguishes your goods and services in the market, including color schemes and palettes, if that's something that's, you're really riding on. So that other stuff is the more protection for the, how do you deal with that internally, your internal documents, to make sure that if they do steal it, if they do set up down the road, if they do pinch stuff or whatever, then you can rely on the contractual agreements that you've got with them to stop them, including injunctions, and damages that can flow from there, because you can't enforce a right that you don't have. And employees are a protected species, right?
Mm.
Just like tenants, just like children, just like the elderly, just like others that are more vulnerable, and that's for good reason generally in society. But and when you're trying to enforce intellectual property rights, you really have to make sure, one, you own it, whoever's enforcing it, that it's that's solid. And then obviously you've got to prove the breach of any agreement if there was a breach of an agreement. But you can also the great thing, the real reason why you would trademark something is because you get the power of the Trademarks Act behind you, and that means that you don't have to prove reputation when it comes to court. So, and reputation isn't as like what you and I would think. Reputation's a lot higher bar to jump. Like, you've got to be really well known in the market, basically. You've got to prove that you
don't have to trademark, you mean?
If you don't, then you only can really rely on misleading and deceptive conduct under the Australian consumer law and this old tort of passing off. You can still say allege a breach of trademark, but it's not registered. So you don't have the Trademarks Act behind you. If you've got a registered trademark for it, effectively what happens is, when there's a breach, if that does happen at all, and we all know that by documenting legal stuff or having stuff on the register or having domains or having this or having that, having presence, can stop people from copycatting in like at all, can stop people from breaching an agreement at all. Some people look at agreements and go, oh, there's a hole there. I can drive a bus through, so I'll give it a go.
Yeah.
But if we don't know how many near misses we've got in business life. But I tell you what, that's why big businesses do this really, really, really well. They have all of their trademark. I mean, Red Bull's got 275 Australian trademarks on, it's crazy. They go to the ends of the earth.
Yeah.
We're not doing that, but at least what it means is that a trademark, an Australian trademark that's registered, means that they have got the exclusive right to use it and to stop others from doing it. A shield and a sword.
Yeah.
Right. So if somebody else comes along, when it comes to court, you look at the two businesses, the two brands, they go, that's a breach of the trademark. Boom, gavel comes down the head. But if you don't have that, then what happens is, and this is what I like, many businesses come to me in a panic because they've had a business for a long time. Someone's come along, they've registered, they've either applied to register a trademark underneath them on the register, and it's been accepted, and now it's in the opposition phase. So now they need to file an opposition to stop them. They also need to send legal correspondence to the enemy, what we call cease and desist correspondence, to basically say, we were here first. Australia's the first to use system, not a first to file. Your trademark's registered in either in bad faith, which is a big high bar, unfortunately, to jump, but it's also, you don't belong here. We were here first. You're breaching our client's intellectual property. You need to stop the business immediately. Give us all the business names, the domain names, all of this stuff over. And we also want to know who you've been talking to, clients, how much profit have you made over the last year, 6 months, 1 year, 2 years, wherever long they've been trading. We also need to file our own client's trademark on the register to put it on there. Of course, the other one, because it was filed first, will come up as an objection. So then we will then need to file evidence of use that we were there prior, which we will have, and then get over the top of them and get them underway. That's another 6 months after that point, until they have a registered trademark. All the while, you've got this other business potentially confusing the market, causing damage, all the rest. Like, you don't want to go there. It's 10, 20, like, it's that stitch in time saves 990, 900, 9,000, sometimes the whole bag.
I think there's an interesting thought there for founders, which is, when you get past the threshold of survival and your business is in growth phase, when you start coming on other people's radars, you need to be in a position. What I liked what you said was, like, you can't enforce a right you don't have. And you need both a shield and a sword. So if you've got the kind of business where someone's going to care about you out competing them, because now you've your head's above the fray, and not like, like, I think about one of my clients where there's like they're in a market where there's like a couple of massive behemoth businesses, like huge, like just giants. There's a super long tail of absolutely tiny little micro businesses. And then there's his business right in the middle, like a very clear number 3. So which would be the aspirational business of all the micro businesses. And an annoying thorn in the side that's starting to take money away from the big guys. And so that's a perfect example of, like, I'm now in a position where I probably need to have my house in order around this stuff, because I'm all of a sudden on the radar with people who've got more money than me, or competitors who really want my position. Now I'm in that space where I'm not just like sliding unseen.
What do they say the 2 best times to plant a tree is? 20 years ago and now.
Yeah.
Like, you should have done it when you came up with the idea. You should have came up when, like, so as I really encourage businesses to, as soon as you come up with a name for the business, right? And it's a big process, right? There's lots of thought and energy. There's probably 50 hours that goes into selecting a name, right?
Yeah.
Come to me for a quick check. I'll have a look on the register for you and just see whether there's anything that's that's a direct conflict that might prevent it from being registered. Before you go and spend all this money on branding and all the rest, like, this is the first thing. This is the first thing you got to start with. But if it's already been like 10 years and you've been trading and all the rest and no issues, well done, good. Like, that's amazing. But doesn't mean it can't happen tomorrow. So, like,
and so for founders listening,
getting it running, and
for founders listening who haven't addressed it yet, go back to what Ian said about 10 minutes ago, which was, we're talking about thousands of dollars, not hundreds of thousands of dollars, to do the basics. And, like, I think you probably, when you start with the basics and you get to understand what's valuable, like, you've sort of protected the base level of the house, you've got the foundations, and actually not at a high cost whatsoever. And then you're probably also going to understand more about the process, and you're probably going to get some knowledge from someone like Ian about what's more valuable in your business, and maybe something you need to think about for the future, so you can build a plan. And if it's going to require some more investment, you can think about that, you can plan for it. But there's clear basics that sound like are very high value for the cost that they are. And I'm conscious how much time we've got left, and I do have 2 questions I really want to ask you. One is,
go for it.
If you could, like, install one belief or one habit or one question in every founder's head about IP, what would that be?
I think you've got to realize that as soon as you're starting the business, you're instantly got this something valuable. I think just taking, I've looked at lots of successful businesses over the time, and one thing that stands out to me all the time, apart from their grit, which is their, like, that's far and away, I think the number one thing. You're going to have a lot of challenges in business, right? And you just get better at getting up after you've been knocked down. But what has been fundamental to our growth and success, and I know to other businesses that I've seen that are gazelles, they take the right advice from the right people at the right time, and assembling that a team of players that and advisors that you can go to from time to time for advice when stuff does come up, tax, finance, legal, marketing, coaching, HR, et cetera, like wherever you, and I think like I'm onto my fifth accountant, like you get better over time. I went through 3 web developers, you get better, you just select better over time. But geez, I wish, if you could if I could have found those right people before, and then, a lot of people come to us and go, oh man, thank God, I'm so glad we found you now. I wish we had you 3 years ago. They're the kind of magic words for me, where like they've been through some pain before. They understand the value of this, and they understand how useful advisors can be. Do not be scared of getting legal advice. Most law firms will do some form of like initial consultation. I'm really happy for just for whoever's in whoever's in this group. I'm more than happy to have even just like a half an hour quick chat with whoever's in this group, and I'm happy to do that gratis, no charge. Like just at least give you some general advice about what you should be looking out for. Leverage off my 20 years experience, and then at least you'll have some knowledge. And I think just that reducing that barrier to getting legal advice is it's really important, because we're not like the traditional firm. The traditional firm, like one of the first ones that I worked for, they all held everything like this, and the internet is going to be a problem because then people will be able to find out all the information and do it themselves. Turns out it actually exploded everything, because people were actually more interested in the law and what it's all about. We avoid stuff that we fear, right? And that's and that sucks. I mean, I'm sure accounting's the same as well too, in a way, because you don't want to be, silly.
You're 100% right. And there's no circumstance. All the smart business owners, ultimately they hire people like me, they hire people like you, like they hire experts who've been to where they're going, who've got specialist knowledge. They're trying to find them at a good price, who've got a good match of their skills and expertise. Because you can't obviously know everything. You do as a CEO or a founder have to be dangerous in most areas. Like you have to learn a lot about a lot of things, but you'll never be an expert in certain things that really matter.
I don't file my own taxes.
Yeah.
Right.
Yeah.
I don't file my own. I don't do my own taxes because I know I'll go to jail, because I'll probably stuff it, because I'll probably stuff it up.
100%.
And the amount of people that try and DIY this stuff, and stuff it up,
And not everyone, of course, will act on their IP straight away, but I think this will have started the wheels turning mentally for lots of people. And but what I'd like to make sure is that there's some, there's really actionable takeaways. Like, let's just say a founder goes, you know what? You're right, I do need to do something about it. And I've got an hour, I've blocked out an hour on Friday. What if they were going to just deploy an hour on this to advance it, to think about it properly, to create some value that they haven't already created? What should they spend that hour doing?
I think the first step is an audit. Like actually going through and identifying all the intellectual property. That's what you can do in 60 minutes. Like just going through and working out, where is all the IP, who created it, if it hasn't been assigned, what needs to be done there? Does the business own it? Yes or no, right? And just going through all of that, we couldn't find when we looked for an IP, for an intellectual property audit for a small business. So we created it. It took us over a year to do, and I'm happy to share that with you, to share to the rest of the group. But or they can go to Progressive Legal IP Audit, and you'll be able to download it free from there. And just I'd spend 60 minutes going through and just identifying all the IP that you've got. And when you start to really think about it, you'll then realize after 60 minutes of doing this, going, oh wow, we've got so much IP. It's actually quite a nice, almost therapeutic exercise, because it's just like when you go to move house and you realize how much stuff you've got, stuff you've accumulated in the time, and you go, where did we buy all this stuff? Like how like we only had this much stuff when we moved in. How have we got now? Why do we need 2 trucks, not 1? It's because like you've amassed all this stuff, and and nothing gets thrown out. If it does, it just sort of goes in the background. But all that stuff, if you document it, you work out, where it is, what you can do to protect it, what are the things you should consider. And then at least you've got then a little bit more knowledge about what's actually, if it was to be named as an asset on your balance sheet, like forget about the value of it, but like IP, what's there, do an inventory, do a stock take. That's what this is all. That's what this is all about.
Got it. And if you've still got 5 minutes left of your 60 minutes when you've done that, well, Ian's just offered you half an hour of his time for free, which is unbelievable and very valuable. I'm sure you'd agree. So jump on the Progressive Legal's website and go and check it out and reach out, because I imagine for you, like for me, if a client rocks up or a potential client and they're super well prepared, they get a hell of a lot more out of that time than if it's completely, if you send him the document, send him the order and go, hey, this is the stuff I've got. What would you recommend? How much is it going to cost me? How do I think about it going forward? And you're going to get some sense of like what you can do about it.
Yeah. And if it's just something, a discrete thing that you're like, oh, I just want to get some like really quick advice about this, like more than happy to have that chat and have a, and then let them know what the cost is kind of involved to do this, or at least like, get some idea about the, what they can do, what they can protect, and in what order I would do it, from, if it was me, what order would I do it in, and just take things step by step. We're really practical. You don't have to like do everything at once. Like it's it's too much. It's too consuming, and it's we just focus in on like what's the most important, what's the most valuable. Let's do that first. We'll knock that off, and then do things step by step. And once you've, I like to encourage, especially when they're the directors of companies, right? There are times when I have had to put my director hat on, not my principal lawyer hat. I'm the director of this company. I've got fiduciary duties to do what's in the best interest of this company at all times. And if it means that we've got to take expert advice and pay for that expert advice and get it, and then make a considered decision based on that expert advice, considering the financials and all the rest, then that's what we have to do. That's just discharging my director's duties. That's discharging my fiduciary duties to do what's in the best interest at all times. And sometimes I think that helps owners and directors make those decisions, because they're like, oh yeah, because I've actually got a higher duty here. I've got duties to the shareholders. The shareholder might be me or my trust, but I still have a duty that I need to discharge. And so that means taking advice from the right people at the right time, taking steps to enforce stuff when it's appropriate. But before that, take the steps to protect it first as much as you legally can, to reduce that risk. Because then sometimes you don't have to go there if that's the case.
Yeah.
I think it's just like peace of mind,
Sorry, we're gonna need to wrap up there, I think, for today. But that's been so instructful is not a word, but insightful and instructive. Thank you. And so if people would like to know more, can you just tell them where they should go if they wanted to either connect with you or learn more about Progressive Legal? You've obviously just talked about an IP audit that you have on your website. So can you just explain how people can find out more if they want to go and find out more?
Yeah, sure. I mean, our website's progressivelegal.com.au. And you can and we've actually even got a search bar in the website too. So there's stuff that you want to specifically, research that we might have articles on or pages on a website. You can put in the search bar as well. If you want to put an IP audit there, that'll come up for you. If you want to email me, it's ian@progressivelegal.com.au. If you want to you can fill out a form on any of the pages of the website to get in touch, and one of our people will line up a time to chat. Thanks so much for the time. Yeah, I really appreciate the opportunity, and I'm glad to. I've tried to give as much as possible. That's kind of what we're all about.
Part of scaling is about avoiding unnecessary pain in the future and knowing what's coming. And so hopefully today you've heard a bit about what might be coming and some ways to perhaps avoid some unnecessary pain. And it's not as costly as you probably think it is. So it's certainly a place that you can get started on some basics for a relatively, a low price. So I think most founders today would think that's probably worth considering. Thank you so much, Ian Aldridge. I've absolutely enjoyed our time together, and I look forward to seeing you soon.